what were your thoughts in group one? Who are the two people who are going to discuss it with us?
I can. So for our group, the scenario is, well, it's confidentiality versus harm. A 15-year-old student confides in you about ongoing substance use or a pregnancy, explicitly asking you to keep this private from their parents. So the dilemma is honoring the student's request fosters trust, but withholding medical or safety information could expose the minor to foreseeable harm or legal liability. We discussed the importance ethically being responsible, your responsibility to students and parents and guardians. If substance abuse, with substance abuse or pregnancy, the student is harming themselves, um, or could harm another if it was a baby and the parent didn't know. And so we have an obligation to inform. Does anybody else want to add on to what we said?
So for scenario one, it says ongoing substance use or
Or a
a
pregnancy?
pregnancy. So I wanted you to look at the two and the difference between the two. Okay,
Oh,
so
okay.
because each one has a different answer. If it's
Oh, I
pregnancy, it's
see.
one answer. If it's substance abuse, it's another answer.
Oh, I see. I see. We also discussed how when you are talking to a student in the beginning of your session, you do inform them about confidentiality. And so telling the student that, our conversation is confidential. However, if it is hurting yourself or somebody else, we have the obligation to inform parents.
So that's true. And so that applies to which of the two, substance abuse or pregnancy?
Um, I would say both, but I'm not 100% sure. I know substance abuse, you are harming yourself.
Anybody else from the group want to jump in? Jump in. What do you think?
Assume it would be the substance abuse, but I could be wrong. So we also did talk about letting the student know, like if they don't want to share with their parents or anybody, letting like outweigh, like showing them other options and letting them know that the parents want like what's best for them and they're going to be there to support them. So maybe try to convince them to let the parents know of the situation they're in.
Definitely, but legally, we have a responsibility. So with substance abuse, um, what are we doing? Are we telling, not telling? Is it confidentiality?
We're
I
Are we
think
telling.
that's
breaching
telling.
confidentiality
We're
with substance abuse? We're telling, right?
Yeah,
There's no,
telling.
there's no if, ands, or buts about that one. Okay, so with substance abuse, you're causing harm to yourself.
Mhm.
That's one of the rules. So that's very straightforward, right? Let's go to pregnancy.
Mm.
I feel like if with pregnancy, it's also causing harm to yourself if you're not letting, I mean, your parents.
Pregnancy is a natural situation. It's available to anybody who can conceive.
Mhm.
And so where's the harm? What's the law? What's the law for medical?
if
Uh,
they're in danger, if it's causing them, and or we can't.
They're not
We
in danger. Pregnancy is a normal situation. Anybody can get pregnant. What's the law?
mhm.
Anybody know what the law is?
Is
Okay,
it HIPAA? Would it
Is
be
it
a
the
HIPAA?
HIPAA doctor?
12. 12 is the magic number. Anybody under 12, you breach confidentiality because the law states that anybody over the age of 12 can make their own decisions medically. So
Oh,
that's
Mm.
it. That's the
all that.
law. So that's the important part. And that's why they had both, separate, like substance abuse versus um, pregnancy. So with pregnancy, um, Adriana mentioned that we're just trying to make sure that we find somebody that they will let us confide in, because, you know, we want to make sure that that person is getting the medical attention that they need. If they're not capable of getting it, this person is 15 years old. So it's going to be a lot of conversation. And you can't go around telling all your colleagues that she's pregnant or she's revealed that she's pregnant. At 15, some of the nurses can give pregnancy tests, so you can do that. You know, so that's available on some of the sites. So that would be something to confirm it, right? So that the confirmation then is it's factual at that point, right? Or close to factual. If you get a positive test, it doesn't mean that it could be that it isn't a false positive, but then that's where you start to have more deeper conversations for that individual as to what are we going to do and how are we going to protect the child, the student while they're here. Okay. As far as the law is concerned, we don't have to remove anybody from school. They can continue to attend school regularly, but obviously that's going to, you know, we don't want people starting to talk about it and things like that, because she's asked for to keep it confidential. So at that point, we're doing everything we can to get this 15-year-old to confide, in someone, so that we can have that conversation so they can get the appropriate care that they may need. Like they may not have medical insurance. That's something that needs to happen. Are they going to keep the child? That's another conversation that takes, you know, that is required with the family. So all of that is something that we wouldn't want to make those decisions, but we would want to provide the student with as much information as we possibly can about their options, right? And again, you don't want to provide the student with options such as abortion or other things. It may go against the family's, you know, background, religion, whatever it is. So that's something that you don't want to just hand out a pamphlet for everything and, you know, make sure of that. So you want to make sure that you're having these conversations and that they can have this within their family structure. And that family member doesn't always have to be a parent or a guardian. Maybe there's another trusted adult, like a cousin or someone who has a better rapport, that you can at least say that she wouldn't allow you to contact the parents directly, but you did contact another family member and she revealed to the family member. And then you had a conversation with that family member as to, you know, how are you related? Are you close to, you know, the parents? Is this something that she should be concerned about? Will you be able to assist in that matter? But you already have received permission before contacting that individual, right? That child has said, okay, I want you to call my cousin. Okay, then you get some background. How are you related? Whose side, you know, that kind of thing before you call that individual. And again, we want to confirm the pregnancy. We want to try to, if that's available for us. If not, it's similar to suicide prevention, in which we're saying, you know, she is revealing she believes that she might be. Okay. So again, that's for the family to make the final confirmation through their processes, right? And it's not our responsibility. You know, we're just that trusted individual that they came to that said, look, I think this is happening to me and I need some advice. And I'm too afraid to go to my family for that advice. And then you say, okay, well, this is how you structure it. You would begin by saying, you know, yes, before we, you know, get started, and I'm here to listen, but I need to let you know that there's some things that I can't keep confidential, you know, and then you let them know that information. And then as they go on and tell a story, you see where that doesn't necessarily apply in this particular situation. Now, with the substance abuse, you would then say, okay, she says she's, you know, on drugs. So most of the time we have a program or some sort of resource that we can give, you know, to them. But again, that's not what we keep confidential. We contact the parent, let the parent know that this is what they're saying. And we want to make sure that they get the support and help that they need, you know, and you give those resources to the parent. Okay. Any questions or concerns about number one? Okay, so that's why they had confidentiality versus harm. One is confidentiality, which we cannot breach. Breaching that confidentiality, if she only tells you and it gets out to all of the other people that, something, that she might be pregnant and then it's on Facebook and all of that. I mean, we have to, that's why we have to be cautious as to if she's taking a pregnancy test on campus, that there is a quiet place or a confidential place that she can do that if she's willing to do that. Um, you have to make sure that she might go out and tell other people she thinks she is. That's another thing that you might want to get um, information from her. Have you shared this with anybody else? Am I the first person? Is there anyone else that you may have, told this information to? Because if it does come up and the parent is the last to know, you don't want that child going home saying, I only told the counselor. And then the parent sues you for breach of confidentiality when in reality, she's told other people. Okay, so that's also important. You want to get your data, take your notes, make sure that you have all the information necessary. All right, group two.
Hi there. I go first for our group. Ours was on the topic of parents' rights to know. The situation is that you discover that a student's unstable housing or a parent's substance abuse is impacting their academic performance, but the student begs you not to tell their parents out of fear of reprisal. Now seeing that it's an or situation, what we discussed in our group for the unstable housing, we did say that for legal reasons, we will reach out to the families. And then what we could do as school counselors, we even offered doing a wellness check. Maybe, in that point, contacting families to see what we could do to work together to help the student and their academic performance. And then for the substance abuse is the one we think would be a confidentiality reason because the child is scared for their well-being of being reprimanded from the family and even contacting proper authorities if need to check in on the child and the family if there is substance abuse involved in that situation. That is where we were. Please give us feedback, just to make sure we're on the right path. And then if anybody wants to join.
So the law for unstable housing, we'll go over that today, but the law for that is there's the McKinney-Vento Act, and so you cannot go against that law. So once she says that it's unstable housing, you need to make sure that you contact the parent, let the parent know of all of their rights as far as what homelessness is, make sure that they are truly homeless. Sometimes they're comfortable where they are. Maybe they, aren't that don't necessarily meet the criteria, but if that it doesn't hurt to go over how they can get support. And you can let them know that, all the rules that follow for the McKinney-Vento and that it doesn't stop her from being able to come to the school. If the parents want to keep them abreast of what's going on, we'll be there for support. We have resources. So prior to calling the parents, you want to gather all of your resources for homeless and your liaison, talk to your liaison. There's always a district liaison. So you want to let the district liaison know that the child has come to you and confided in you and that, you want to reach out to the parent and so that the liaison also is aware of this potential. You can say, as soon as I reach out to the parent, I feel comfortable reaching out to the parent, I'm going to discuss it with the parent. And then I'm going to give the parent your telephone number, the district liaison. And then the district liaison would go ahead and say, yes, that's an excellent idea. And then that way the parent can then reach out to another individual that can support them through this process. For the parent substance abuse, this one is a little tricky, right? So this one is she's fearing that she'll be harmed, right? So you have to, this one is what type of rapport do you have with this parent? Can you get additional information from the parent? Are there two parents? Maybe they live with one and the other one can provide additional information for you. This one is really sticky because we don't want anything to happen to the child, right? But at the same time, they're not in a good environment either. So this is something that we have to try to, kind of work out right now. The child is not in any harm's way, but we can use this to, say, oh, you can contact the parent to say, let's have an academic conversation about your grades, your attendance, whatever is low, right? I can call your parent in. We can only talk about academics. Once you begin talking about academics and how to support them and see if they're willing to come in on that, you don't bring it up. You see if you see any additional signs. Is it reportable? Is this person, what's happening? Can you get more information? It might require you to call child services, depending on who's watching the child. How often is the person going to work? Are they missing work? This also could occur with what Jennifer mentioned, a wellness check. A wellness check would allow you to go see the family, go see the house, see if it's worth a call to Child Protective Services. Like if the house looks straight and in order and the individual is drunk, there's not much you can do, right? Child Protective Services isn't going to do anything. They're drunk in their own home. Okay. As long as they are not harming the child and you don't see any harm with the child, you just, there's no reason to make any further. If there's no food in the refrigerator, if there's no bed to sleep in, the same things that the social workers do, look for, you would then call out and say, but you're on a wellness check. So you could say, I'm here to help. Is there anything that you're open to discussing with me as a school counselor that I can provide additional supports for you? When I go out for wellness checks, I go with my social worker. So that's her job and I have my job. So I would discuss with the parent about how she's been late to school. It's affecting her academics. She missed 10 days. She hasn't taken her exams, and see what can I do to help her? What can you do to help her? Can she stay after school? Should we put her in the after school program where she can get those things done, or he or she can get those things done? So, that's what my conversation would be about. And then my social worker would then step in and say additional information as to how they can support the parent, the family with additional resources. And so that wellness check is an excellent idea. How many people do wellness checks, or their school or where they're doing their field work, that they do wellness checks? Okay, good. Mhm. There was a time when we did not. School districts had strict policies against that because they couldn't protect the family, the employee going out to the homes. And so there were times like that. So you always have to kind of look at the day and age and what's going on, and if your district supports that, because there are some things that they don't support. So you don't want to go out on your own and then something happens to you and the district says, well, we never told you to go. So that's important as well. Okay. Third group.
We looked at let me go to our scenario. Advocacy versus school policies. So a student discloses bullying or unfair treatment by a teacher or administrator. We kind of did talk about both situations, not knowing that it was the either or. And we talked about validating the student, so advocating for them, and then kind of that dilemma of well, if it's a teacher, doing a little further investigation. So still kind of trusting the word of the student and then going into the classroom to observe to see like what's going on in that situation versus just outright saying, okay, I'm going to follow what the admin says by listening to the teacher's version. And then with the administrator, this one was trickier because that's like your boss ultimately. If it's them who's giving bullying or unfair treatment to the student. So I think that one was the one where we kind of were iffy on what to do in that specific situation.
Okay, so with the bullying, the teacher, the principal has to investigate, right? They have to follow the same policies and procedures. And every school district in the state of California has to have a bullying policy and procedure. So that's the first thing you would go to. What is our policy and procedure when someone reports being bullied? And it should, be specified as to if it's a student, teacher, an administrator, and who you go to. And so that should help you as far as that's concerned, as far as like, who am I going to go to? Who is my trusted individual? The other thing is, if it's a teacher, I think, say your name again,
Arquea.
Shaquaya indicated that we would go and do an observation in the classroom. So doing that observation in the classroom would allow us to be able to see what happens, how the teacher responds, and so that the administrator could then give feedback to the teacher, or you could also advocate. Sometimes the student is strong enough to talk to the teacher themselves. So depending on the age of the student, right? So you would want to set up like a peer mediation, but the teacher is on the other side, and you would get consent from both parties. Are you open to talking to your teacher with me there present to let the teacher know how you are feeling, right? And you still follow your bullying policy and procedures, like you reported it, you did this, but your solution is to have a peer mediation initially to see if you can get them on the same page. Document, what the teacher said, what the students said, if they at least respected and heard one another. And then that's more evidence for the principal if the principal needs to go further if it happens again and again. Because usually with the bullying, the first incident, you aren't going to really get a lot from that. If you're being informed and you write it down at this time, and then the next incident, the principal has to act on it, because it's like, okay, they came to us, he or she came to us once, here's the next incident. Now they're coming back, they're bringing their parent. Another thing is, I always say to my students, tell your parents. Tell your parents. So I'm here to help you while you're here. You can always come to me. You can always have a timeout in the room. If it gets too overwhelming, if you feel frustrated, provide that support so they have a safe place on campus when it's occurring. But at the same time, tell your parents so that, and then once they go home and tell their parent, you can say, you can reach out to the parent. I wanted to let you know that the student had a mediation with the teacher. These are the concerns that they have, but I want, to let you know this is happening. So that if the child goes home and says something else, the parent can say, well, the counselor already called, so something must be going on. Now, not to say that the next incident won't be perceptual or two different perspectives, but it's the important part that the parent is becoming involved. And the parent, because there are a lot of parents who just take the stance, the adult is right. But is the adult always right? So that's something that we want the parent to hear from another adult. This is what's being stated. We had a mediation. The teacher has decided to solve the problem in this manner. So I'm letting you know. So that way the parent can, and you can get, confirmation from the teacher. I'm going to contact the parent. Are you comfortable with me contacting the parent, letting the parent know that we had this conversation? Okay. And then the teacher would say, yeah, I mean, I said she should be informed, or he or she should be informed, just so they know what's going on, but that you've made this solution and this is what's happening. But if something is ongoing or it continues to happen or there's no change, you have addressed it, and then it needs to go to our higher source. This is also where we might change a classroom, right? We might do a class change as counselors, because that might help the situation. And I do that a lot of times as well. I'll go into the principal and say, this isn't working out. And I don't want to, say who's at fault, but this isn't working out. And it's not in the best interest of the student, at this point. or we're not getting the best from the student. So do we have another space for this individual? I usually already check to make sure that we have the space available. And then I say, I would like to go this way with it. And then the principal will just let you know if there's other things like, no, I can't do that because there's something else going on, and they might not be at liberty to tell you that additional information, but at least you're out there problem solving, saying, and then when you're going to the administrator for that class change, you're also saying, well, I met with the teacher, I met with the student, we met together, and the students, and we met on this day, the teacher stated this, and then I contacted the parent, and the child came back to me again. I did an observation. This is what I observed, so that you can have more information for the principal, so that they need to move forward if a class change is not available. All right. The administrator, follow your bullying policy. Who is the head of the person? It goes directly to people, usually directly to the people personnel services. That's the person who's in charge. You might have to go over their head, because if they feel a certain type of way, maybe it's the parent, maybe it's the child, maybe they've had problems with the child in the past, all of that could be a possibility, or they're just blinded by it. So, you definitely might need to go above their head and just say, hey, this is what I presented, this is my documentation, this is what I've said, and this is what I've done. And the principal has not given me a suggestion as to how we can, move forward with this. All right, number 4.
Hi, so we discussed number 4. For the first scenario, well, this is more just about boundary management in our digital age. So the scenario was that a student sends you a friend request on social media, and we talked about how as much as it's important that a student feels comfortable with us, and this could be an indicator of that, you also want to avoid any dual relationships. And depending on the age of the student, even maybe sharing that with them and letting them know, like, hey, because of my role, I can't, like, this isn't something that we can do, but like I appreciate you, feeling comfortable enough with me. And then again with the parent attempting to discuss child's grades on your personal cell phone, of course you want to honor any attempt of a parent reaching out to you, but again, to avoid the dual relationship, it's important to provide probably your email or like a work cell phone, just and let them know, like, hey, we can continue this conversation, but on my email, or if they want to schedule in person, just so that you always avoid those dual relationships.
Excellent. So most of us are not fortunate enough to have our cell phones paid by, or an additional phone, a work phone, because our role isn't high enough. They usually leave that for our district office people. So I would say some of the things that's happened most recently with us is we had an update, and we bought a bigger amount from Power School. Power School has a texting section now. And so they probably have had it for years. We're just late. So let me not say that. We have it now. And so that has been a saving grace for me, because there's a lot of parents that won't answer emails, and they don't answer phone calls because of all the spam and all of this. So sometimes when you can just send a quick message, can you call me? Can you call the school? Can we have a discussion? They answer you right away, and they get to you right away. So I would encourage that, as far as being able to, contact them using other means of contact. I think sometimes I have a lot of students from other countries and families from other countries, and email is not a big deal, or they don't use email in some of these other countries where my students are from. So we're asking them to join something that they're not familiar with. They don't know, they don't set up emails. They'll set up a temporary email just to log on and to do our enrollment, but they don't use it frequently. So we have to kind of match what they're doing. So having that text message or something else, and another form of communication in order to do it. We were using Class Dojo, which for years, but Class Dojo is not secure. So We've been asked not to use it by our superintendent. So that's another thing that our power school has, really helped us with. So yeah, and then dual relationships, as the book has discussed, they're needed at times. Like sometimes it's just, what are you going to do? Your cell phone is really personal. Your social media is really personal. You have photos and things on there that you may not want your students to know about you. Not that it's something you're ashamed of, but just something that you don't want them to have access to, right? But you going to an event of theirs or a party of theirs is a dual relationship, but they're not stating an ASCA standards, is no longer saying that they're just not okay. They're saying that you can participate in them, but you would want to participate in them, like going to an event, a quinceañera, a baptism. Those are really, those are social events, but you attending and having a gift and congratulating them and leaving, you're there, but you may not stay a long time. You know what I mean? So you're not going to interact with them the same way you would interact with your friends at those events. So but being present it is a dual relationship, but it isn't discussed as negative or you should not do it according to ASCA. Okay. So keeping that in mind also. And number 5.
For number 5, we as counselors were given a 4th grader whose name was Julie. She was referred to us just to kind of check in. One of the things that came up was dad was in jail, but the bigger thing is that they're housing insecure. So our discussion kind of went a little back and forth between what could and shouldn't be done. We thought that the jail thing was sort of irrelevant because based on what our scenario says, there's no safety issues, none of that kind of stuff. So if it were to come up, great. If not, it sort of doesn't matter. But what we can and should address in any shape, way, or form is the home insecurity using the school resources as mentioned earlier, the McKinney-Vento and or whatever other resources your district might provide. First of all, would be creating that relationship between the student as a 4th grader, right? It's going to be slightly different. Make the student feel they've done nothing wrong. Everything that's happening, it's fine. It's normal. It's something so that they're okay. Even if the student in this scenario says doesn't want us to reach out to the parent, I think having that transparency of you're not going to be in trouble. It can be one of those things that I'm doing a follow-up, a checkup. Hey, I noticed Julie was tired today, all good. And if it came up or come in, find a way to get the mom or the parent who is available to come in addition to letting them know, here are the things we did find out, here are the resources you can use. As of right now, there's no additional thing that we have to do because as of right now, we're not seeing anything like a safety issue or any of those things. Please utilize these resources. As mentioned earlier, it would be a version of having our social worker and or whoever needs to be as part of that conversation to be there as a resource and again, encourage them because in the scenario I said that the parent did make efforts to stay at hotels and there were different things and they didn't stay at hotels only when they didn't have enough money. So there seems to be an effort to want to keep things as normal as possible. And here are the resources we can help you to do that kind of deal.
And our social workers have access to getting them funds, additional funds, sometimes with hotels. So that might cut that down. So I've learned a lot from my social worker, but that's just information I'm supposed to put in my head, not necessarily take on as my responsibility. So we work, like I said, as together, and we make sure that all that stuff is, and it changes daily. Like she'll tell me, oh yeah, nothing's happening now. Like, oh, there's no housing, there's no this, there's no that. But then there's other times where she gets really far and she even gets a family placed. So it's very sticky and it depends on how much experience they have. My social worker has like over 20 years of experience. So, and she's worked in all, San Francisco, major cities. So she's very familiar. So, it's just about how to help them. And that's what you want them to know because your school social workers, their primary function is they're not affiliated with DCFS in any way. They're just a mandated reporter, just like the rest of us. But at the same time, that's what we want our families to know. Like we have additional supports here on and within our district that can help you navigate the system. Because I tell you, it would be difficult for me to navigate the system because you know how you are when you're trying to get information, whether it's from the medical, whether it's from this, and they say, oh, there's nothing you can do, oh, there's nothing you can do. And then you have a friend who says, well, I got this, and this. So that's how our parents feel. You know, you give them a number and you say, oh, they'll help you. They just helped this other family, but this person doesn't ever get a call back or doesn't even, get the answer or anything like that. So we just want to let them know. And a lot of times with my social worker, she makes appointments and she sits right there with them and makes all the phone calls with them right there at the school. So that's helpful so that the parent really, if they don't understand what the person is saying on the other line, the social worker can get that additional information for them. Okay. All right. I hope that was helpful and you learned some new information. All right. I'm going to go into chapters 5 and 6. All right, so this chapter is about negligence and obligation to the court. So we'll be talking about what is our standards of care, liability, and student advocacy based on our ASCA ethical standards and landmark cases. So when we're looking at negligence, we have civil liability, and it relies on the preponderance of evidence to prove malpractice, and 4 mandatory elements must be present. The 4 are 1, duty owed, 2, breach of duty, 3, causal connection, and 4, injury suffered. So duty owed is the counselors have the legal duty to protect the student's physical safety. So as we're talking about are they in any type of harm's way? Number 2, it's the standards of care test. So did the counselor act as reasonable and a competent professional would in that specific situation? And then we have causal connection, which was the harm predictable? Now, I want you to underline the word predictable because predictable is what you're saying. So if we see a pattern of behavior and we don't intervene with that pattern of behavior, then it is foreseeable and maybe even predictable, okay? But just because a kid has one fight, it does not necessarily indicate that they will have another unless there's more going on with that student. Then it becomes, all right, well, it wasn't necessarily foreseeable, okay? So, or predictable that there was harm was going to happen. And then injury suffered, the actual assessed damages. So monetary, emotional, and physical. And so we look at this because usually with negligence, and there was a case involved in this one where a counselor's duty was she had to go into the lunchroom and observe the lunchroom at times, but she wasn't assigned lunch duty. It was just part of her job, just her, to kind of go in there. A fight occurred in there, and the parents sued the school because of harm. The child was injured during the fight. Originally the counselor broke up of the verbal argument, but when she left and came back, and she separated the two, the two students still got into a physical altercation. So that is why the parents felt that it was predictable. Now, when the judge ruled that it wasn't foreseeable. She had done what she was supposed to do. She separated They calmed down. Everything was okay. There was no evidence that there was no threat or additional evidence that the student was going to go back and they were going to get into a physical altercation and that the student would be harmed during that physical altercation. So when we're defining standard of care, we are looking at, there's no, the courts don't demand perfect or extraordinary care. They demand reasonable care based on these three foundational tiers: our ASCA ethical standards, our district policies, and our state and federal law. So our ASCA ethical standards are our guidelines. That's the one that's saying the big umbrella that are we following those standards of care? What are the gold standards for the profession? And are we defining the expected competencies? And so that's why we make sure that those are up to date as much as possible. And they're reviewed every 7 years, because the ones, if we look at the ones that were available in 2016, they're missing a lot of what the world is doing today. Our district policies. These are our school board procedures that must be followed unless legally challenged. So again, there are laws that state that we have to have board policy on certain topics. Two of the ones that fall under our umbrella are bullying and suicide prevention. Okay, so those two fall under our umbrella. There's more, of course, but these are the two that we come in contact with the most. And then our boundaries, our statutory mandates and constitutional limitations. So, what are those as far as like how long do we have? How long can someone sue you for that? So, as we know with sexual harassment, the new law is 40 years, right? So, the statute of limitations is 40 years. So, the last year at the beginning of the school year, they had, the videos that you do on sexual harassment and making sure that you report it and making sure that, you're not just walking by if you feel like you think something is going on, but you ignore it because you look at the adult and you say, oh, the adult is a good person and whatnot. But we have grooming and whatnot. You can be retired sitting on your porch and they can serve you a subpoena and you can be sued because the statute of limitations is 40 years now. So that's a really long time, and that's something to think about. So when we're doing advising and recommendations for our high school, we have to make sure that we are paying attention to the preceding laws, the preceding cases that have guided us. So with academic advising, we had the same case where they gave erroneous advice, NCAA eligibility requirements. And this was in 2001, and the courts established that they provided incorrect course information leading to the loss of the scholarship. And that was neglect. Okay. So it requires sign-offs for critical graduation and eligibility information, and it puts the onus on the student to confirm the NCAA approval list. Okay, so you want to make sure that that's available. The brag sheets. The trap is students provide false information on applications. So we want to make sure that when they give us our brag sheet and we're writing a recommendation, that it's true and we can validate that. So we're not the investigators, right? But if it sounds a little off, or that the student was doing other things, how could they have done that as well? Then you don't want to include that in your recommendation. You need to rely on the student to self-report, but require contact references for the activity to encourage honesty. So don't just write something blindly because you really like the kid and you really want to support the child and you really want them to get into school, because that could also be problematic in the future. We don't want to include any negative information in a recommendation unless it is substantiated and by multiple reliable sources. Look at your sources. You don't want to go through anything that could be hearsay. It has to have documentation. Okay, so just because a teacher's been there for 20 years and said, oh, they all lie, oh, they all did this, that's not reliable, a reliable source. She could be right, but that's not necessary. That's not what the court is going to take as reliable. Okay, so in suicide prevention, we are looking at talking about the pivotal case was in 1991 following a tragic suicide pact where the courts ruled consequences of risk is so great that any notice of suicide intent triggers an affirmative duty to notify the parents. So notification to the parents is always, it doesn't matter if the risk is low or high. You should never just send a student back to class and then you never contact the parent. Even if the student says, oh, I didn't mean it. Oh, I didn't mean it like that. Yes, I said it. Then I said it to everyone, but I didn't mean it. I just was frustrated. I just was angry. You still contact the parent. And when you contact the parent, that's how you inform them. You know, this is what, you say, you write down what they say, you have that information. One of the strategies I use with my risk assessments is I make sure that I write down what the student says to me the first time, their exact words, and then I have them repeat it to their parents so that I'm not saying it, but, and then I'll clarify, like I'll say, well, these are the words that they stated to me. So if it's somewhat the same, close to the same, that's fine. But they understand that I didn't ask. I'm not asking leading questions. I'm not asking for them. I ask them, what did you say? Who hurt you? And so on, so that they can tell their parent what happened and why you're calling in the first place. In negligence law, suicide is typically considered an intervening variable that breaks the causal connection between the counselor's action and the injury. So we want to make sure that we've taken action, we've given the resources, and that the parent is aware. Because a lot of times, if the parent leaves the child alone, you have had your conference, had them sign, given them resources, and then if they choose that it's not a big deal and they leave the child alone and the child causes harm to him or herself, then that falls on the parent, right? And you have all of your documentation that you went through the processes, right? And then the exception is you're legally shielded unless your actions demonstrate willful and want disregard. A failure to notify parents constitutes that disregard. So we want to make sure that we don't get so busy that we forget, even if we don't think it is a high risk, like the student stays at school, the parent should be notified. And I always do it in person. There are times when you have to do it by phone. For instance, I had a situation where a student did that and the parent had no car. And they said that they were an hour and a half away. And they were on the bus and they hadn't finished work. So I had the parent come in the following day, but I documented and made sure I got my signatures on those other days, so that I could have that information for me. Oh, Kevin, I'm sorry, you had your hand up?
Yes. No, I'm trying to lower it. There it is.
I'm sorry.
No, you're good. Just a question on this, right? The exception, you're legally shielded unless it's a wanton disregard, right? So even if a kid comes and says, just kill me now, or I just want to kill myself because of this, right? Kiddingly, whatever, not, I can still do a phone call. And it doesn't matter how I present it, as long as I say it. Can I say, hey, Kervin, I just want to let you know, I think he was kidding or whatnot, but I just have the legal right to let you know that this happened and it's something you should look out for, and I need you to come in and do the paperwork or whatever that I need you to do. I'm no expert at this. I just need to legally let you know that this happened, even though it sounded like student was kidding or whatever not.
So if they say that out loud, you want to go through your protocols. Like you want to definitely we use the Columbia protocol because that's the one that's the least restrictive. So it doesn't require, you can download that, you can download the app, you can say, okay, you're saying this. Why are you saying this? It helps you to kind of format the questions that you want to ask. Have you felt this way before? Just don't stop at what, oh, I didn't mean it. Okay, I understand that. What's going on? Why are you blurting that out? So you want to have more conversation with the individual just to make sure that you just didn't stop it. And then you get all of the facts. Again, the student says, I really didn't mean it. I've never done that before, but I just got really mad today. Fine. What are some ways that we can help ourselves when we're really angry? Now you go into your SEL and you help them with that. And then they go on your list. Need some, go
So
ahead.
this is one of those things that can just become a conversation like, all right, time out. Sorry, student. You did say something and I have to follow up with this. This is how you
Absolutely.
stuff. And then
Absolutely. Because
they'll
if
follow
you,
up. Okay.
absolutely, because you don't know if they're telling you they only said it this time. But what if someone else said that they heard them last week and nobody told you? So now you don't want to not have had that conversation. And then something does happen. And then it's reported that the student, when it happened at my school with me and the student tried to attempt harm in the after school program, I had a history of problems that the student had been experiencing, both personal, but the parents, mostly personal for me, because it was the home life. But when the incident happened at the school, the parents wanted to only focus on the problems that she was currently having with students. And so we became a part of that. But we had all the documentation. Well, I had SSTs about her academics and the things that were revealed during the SSTs about the parents and their home life. So that was a stressor. The situation with the students at school was the green light for her to do it that day because they were in the after school program. They were, uh, making her feel uncomfortable, teasing her and whatnot, and they had teased her here and there. But it was a combination of the history of things, right? So we weren't informed of anything about. She had never come to me about peer relationships, but I had tons of information about home life. So you can see where the disconnect was. So this is something that you always want to investigate. I was shocked when it happened. I mean, like, what peers? Like, she's the nicest kid. Who's teasing her? So again, and it was happening in the after school program. Still my students, still my students. However, I wasn't there in the after school program. I didn't know anything about it. And it wasn't reported to the principal or anyone else within the district who oversaw that program. So again, this is why you want to make sure that you investigate everything because it can quickly be two things real fast. Then it's three things. And now you're saying, okay, I've done a risk assessment 1, 2, 3 times. Something's not right. I'm going to get this student some counseling. I'm going to get them more support. Something's going on. Okay. So that's why you want to make sure that you investigate every little thing. Okay.
Got it. Thank you.
No problem. So as we heard in the ASCA ethical standards, we're using the tool like the Columbia protocol, but we are not determining. It tells you low risk, medium risk, high risk, but you're not sharing that with the family because it's not a good screener to be able to determine that risk. Okay. All we're doing is saying, which one? We use the low, medium, high as to when should the child be picked up and taken home and taken to another environment, or when should we call for the psychological assessment team? Okay, so that's what we're using the low, medium, high. Our next steps, right? But our next steps are never not to contact the parent. It's just who are we contacting first? Okay. Because if it's high, we're going to the PAT team, right? And we're going to have another evaluator come out. They may not take the student. They may not house the student. So then the student's going to come back. They've been evaluated, but now you've got to put your, everything together for how you're going to support that student when they return the next day. But they haven't just been evaluated by you, they've been evaluated by a professional. Okay. So that's where we don't use our risk meters. Our risk meters are what helps to guide us as to, do we need to call the police, the psychological assessment team? That's what we call the PAT team. Or after the assessment, we have determined that the student is okay to, we might want to send them home and have them in the care of their parent and have their parent. Many times I send them home and I say they can't return until they're evaluated by a professional. Okay. So those are other things that you can do. And then the parent can't just bring them back because they need a doctor's clearance that says that they've been evaluated by another person. Now, the difference between that is the PAT team may or may not come. It kind of takes you, but when if they have insurance and they can get to an ER room and they get evaluated faster, that's maybe a little more helpful for the parents. Okay, so you have to look at those two things. All right. So we never want to, predict safety based on the self-reports, which is the protocols that I'm talking about. And we never want to dismiss the self-reports by denying harm as untrustworthy, which is what Kervin was stating. We don't want, even though we think it's really light, we still want to inform the parent. And we want to treat the peer reports as highly credible and gather other holistic environmental and social context. That's why I said we don't want to stop at just that. We want to give them additional supports, maybe bring them into counseling, offer the parent, I do counseling. We can sit and we can work on ways that they can be less frustrated and so on. All right, so when we are responding to suicide ideation, we want to, one, receive the outcry. We've talked about that. Gather context, notify the parents, refuse to reassure, and then don't minimize the risk to ease the parent. That's another thing. So we want to make sure when they're present before us, don't say it's not a big deal. I don't think it's big. I'm just following protocol. This is what I have to do, because the parent's not going to listen to you. You just say, these are the resources that we have. This is what they said. This is what we do in those situations, and offer other services. Like, you have counseling services. Do you think that the students say that they're open for counseling? How do you feel about it, mom or dad? So you're making sure that they hear that maybe they just need someone to talk to. Maybe there's something going on. Maybe they're going through a phase. There's nothing wrong with getting some counseling for those services. For those ideas. And then 5, provide resources and documentation. So that's where you make sure that you discussed all that with the parent, wrote down notes, and they signed that a risk assessment was completed on their child, and that's your documentation that, and you hand them a copy of it. Okay. So navigating our dangerous district policies. So sometimes our policies are unrealistic. The two that we have, like I said, on bullying and on suicide prevention, we're a part of those as school counselors. So we're in the trenches. We get a chance to go over those policies and get our 2 cents worth in those policies. But sometimes the law states that we have to create a policy and your district doesn't write a solid policy. So if it's not solid and it has a lot of gaps, make sure that you let the person in charge, the one who wrote it, the one who had it board approved, that there's a lot of stuff missing here. This left us wide open. Now, with a threat assessment, there is no law that states that we have to have a board policy on a threat assessment. And that one is really, really loose. They don't want you to have too much information because if someone doesn't follow the policy, then it leads to a lawsuit. And if anybody gets injured with that threat assessment, that's going to be huge. So that's the one that's kind of the most loose. I bring that up because we usually are a member on the threat assessment team. We are not in charge. The administrator and usually someone in charge of discipline, whether it's a dean, an assistant principal, those are the lead people. You come in only as the mental health. For example, if they start to have anxiety, an anxiety attack, that's where you provide your services. Again, you're just there to help calm the student, help the student tell the truth, and document anything that you need to document. Because you want to be a part of the team so you hear everything. You don't want the team bringing you a person who has now threatened to cause harm to him or herself after they've done the threat assessment, because now you're not in the loop. Does that make sense? Okay. So you want to comply with all of your documentation that the policy has. Use the what if scenario, walking the administrators through like, what if this happens? How are we going to document this? How are we going to, and then we can just make sure, especially if the policy is really loose, and then we need to build alliances and make sure that if there needs to be reform within the policy, that we can actually create reform. All right. So confidentiality versus privilege. Confidentiality belongs to the students. The counselors promise to keep those secrets, but this can be broken for the serious and foreseeable harm. So if we know that someone's injuring someone else or threat wants to cause harm to someone else, again, that's the same thing. The privileged communication, that belongs to the student in a court of law, and it's only granted in a few states. This is one of the ones we don't need to be worried about because it's not granted in California, but it allows the student to render a counselor legally incapable of testifying against them. So that's the privilege. The dual licensings, and this might apply to some of you. Some of you might move on and do your LPCC. You might move on and you might do the MFT. So then you'll hold a license. Once you finish those programs have licenses. When you are a school counselor, we don't have a license. What you have to be clear of is what is your role within that district. You can have an LPCC or an MFT license, but if you are employed by the district as a school counselor, then you need to follow the school counseling ethical standards, not your licensing ethical standards, because you are not employed by the district under those circumstances. Okay. So you have to make sure that you're real clear with that and that you don't cross that, that you don't apply your licensing standards of care to what a school counselor does, because it's two separate things. So the subpoena. So when you get a subpoena and it's issued by a lawyer, a clerk, or a notary, you don't have to immediately give over your records. You want to go contact the attorney, the district's attorney, and they have that all set up for us under our our teacher association and everything. So they'll get you the support that you need. You also have ASCA that can get you the support that you need by being a member and getting any kind of questions answered about the subpoena and what you should turn over to them. And then the court orders, those are issued directly by a judge. You have to comply. So you might need to provide testimony or documents and testify, and ask the judge to use only pertinent notes in chamber to limit the exposure, especially if you have a lot in there. The custody battles. Okay, this is like I told you, my court order book is about this thick. So these are the ones where they play against you, and especially the ones that are consistently fighting, because they're usually fighting over money, trying to take away the other parent's total rights, and so on and so forth. So with the custody battles, just making sure that you note the information, but that you don't provide anything to the courts on behalf of them, because you don't know who's telling the truth and who's not. So it's really just you're listening, you're you're supporting, you're letting them know that, their child is your client, and you have your client's best interest at heart. And, giving them, this is where you would bring in the social worker again, because the social worker really needs to work with the two of them to figure out how they're going to provide a safe environment for your client, so that they can get the support that they need and they can do well in school. Parents often attempt to alienate the ex-spouses and use the counselor's responsive services to extract ammunition for the court. So we don't want to be that person who provides that stuff. So maintain strict neutrality. I have had to say this over and over and over again to the administrator, to the dean, to the principal, because they get emotional and they say, that person's lying and I like this person better. The parent should know that you like one more than the other. You just bring them in. You keep it professional and you listen to both parties. If you are forced to testify, speak only to observable student behavior and student performances. And then explicitly state to parents that ASCA ethics prohibits acting as a family mediator or custody evaluator. So you're there to enforce the custody, like who gets to pick up what days and so on and so forth, especially if the court order states that it has to take place at the school. Okay. A lot of them say at the police department at 6:00, but if the return or they have a restraining order against one another, that becomes our responsibility as well. And it's our responsibility just as far as the child is concerned. Is the child with the right person upon returning? And did you release the child to the right person on the right day? Okay. The McKinney-Vento Act, we talked about this one, right? And the law states that we're required, that districts are required to identify our homeless youth, and that we need to provide transportation, meals, and stability. So the district homeless liaison officer has a legitimate educational interest. So that's why we're contacting them. And that's our FERPA exception. And the law supersedes ethics. So you must breach confidentiality and report it to the liaison, which is what we discussed in our scenarios. Okay, the First Amendment, this is one of your assignments. So the educator and the students do not lose their First Amendment rights at the school gates, and that speech is not absolute. Administrators can preemptively suppress expressive speech if they have a reasonably founded belief it would create substantial disruption. We've seen this with some of our walkouts. And then current threat, school boards are increasingly using content neutral policies to legally suppress political symbols such as Black Lives Matters, flags, bypassing the need to prove direct disruption. So when you're navigating the new laws with the critical race theory and DEI, we want to make sure that we translate academic terminology into universally understood concepts and frame lessons around workforce skills, life readiness, and collaboration. We want to anchor to the standards, explicitly tying all of our lessons that we create, college and career, our SEL, and all of those back to the ASCA mindsets and behavior. And so that we defend our curriculum as basic skills required for civic and career success, and then build our parents as allies, share our curriculum with them, let them know that you'll be doing class lessons, post it, print it, even share it, put on your website, the curriculum that you have, so that they don't feel like, oh, you went into the classroom and you said this. No, this is what we discussed. Yeah, that came up, but we moved on And that was out of curiosity from the students. So here are our practitioner legal checklists. Never guarantee outcomes. So that kind of applies to that NCAA and graduation advising. Never quantify suicide risk. Maintain strict neutrality. Law supersedes ethics and document compliances. Okay. All right, I have 4 minutes to go. I did well. Okay, so we have next your next assignment this week is which one? Let's see. All right, so you have your discussion board that's due on tomorrow, Thursday, for your initial, and then also your this week you have your personal and professional views. So you're watching your videos on your LGBTQ plus AI, and next when we meet again, you'll be presenting your historically underserved student population presentation. So our historically underserved is the group of people that have historically been underserved over a period of time. And so we're focusing on that. When you're looking at your courts and you're looking at things that are about negligence, about the themes that are in the book. Okay. Yes, Aries.
I'm so sorry. I know you mentioned we had a discussion board due tomorrow, but I don't see it
Oh,
on
I'm
my.
sorry. No, you don't. No, you don't. Not for a week. No, you don't. No, you don't.
Okay,
It was week 1, 2. We skipped 3, 4 is our next.
okay,
That's
perfect.
correct. I do want to share. Okay, so when you're looking for your court cases, I want to show you how we going over. This is a court case that I found on negligence. So what I did was I looked for court cases and I put in the theme of negligence. I don't have to have it matching as far as like whether it's all elementary or this or that. So this one was about a student in El Segundo against El Segundo School District in 2000, I think 2008 or 9, and it was bullying. So bullying was the school did not protect the middle school student from bullying. Okay, so I just want to give you an idea of we're not looking at a population that we're looking for. We're just looking at a court case that happened and then bullying is also a theme in our book, right? So bullying is a theme as well as negligence being a theme. And so there you have it. There's one case. Okay. So then I would find 2 more cases as I begin to look at. Again, you can use the cases that are in the book, but you can't use the book as your sole point of information in regards to the case. This, I have the whole, when it was filed and all the pages of the case, as you can see. Can everybody see that?
And obviously
Yes.
the case serves as a source, correct?
Absolutely. Yeah. So the case itself is a legal documentation that's become public and, and it has been resolved. Again, if it's newer and it is still, maybe it hit one court and it's going up to the next court, that's okay too. You can write that in there. Don't discard that particular case just because it hasn't been resolved. You would state that in your documentation as you're writing your report. Okay. This one's 33 pages, so it has all the details of it. It talks about the precedents. I could even use some of the precedents, as my source. So that's what you want to do. Okay. And I went to so many others. This one was in 2005. a negligence claim against a school following the son's suicide. So now we're talking about suicide, but it's still negligence. So my theme now becomes negligence, not so much bullying. Does that make sense? Okay. And then I'll show you one more. This is the Supreme Court of Delaware 2013, and this one is also negligence. Okay. And I found this, and this is under fine law. Okay, so somewhere in here, this is just the brief right here, but I usually want to download the entire actual case, like I showed you with the first one, so I know that I have it all and that this isn't someone's account of what happened. Okay. Any questions or concerns about the final assignment? Because you should be by next week, you should have your 3 cases and start writing the different portions of it. The total assignment pages is only 6, I believe. So you do need to have a lot of details in it, and you will get it when you have those 3 cases. As I showed you, the first case was 33 pages, but I've got to read the 33 pages to understand what the case entailed. Okay. So that's something that you want to make sure that you're getting those right away to plan things out. I know you guys are vacation. I too will be vacationing. So, you know, you want to make sure you're planning everything out so that you don't get down to that last week and you ask for more time. On that final week, it is almost impossible for me to give you more time. I have to turn my grades in on Sunday. So the assignment is due on Wednesday. I tell all my students, the more time you get is just Sunday. That's it. If you ask for an extension outside of that, I have to put a 0 in for that assignment. Okay, so it's really, really important that you start as soon as possible so you can have it written and you're not just in case of some sort of crunch. Now, something unforeseeable happens, you got to contact me about the unforeseeable part. If you're down and out, you want to make sure, like, you know, that a relative contacts me, somebody contacts me saying, I am the relative of this person. She is hospitalized at this time, because then I need to see how I can support you with those circumstances. And I have to reach out to the dean because they haven't been giving us any leeway on any of that. And so I want to make sure that you are able to finish this course and that you don't have to retake this course, okay? For costly reasons, all right? All right, well, thank you, everyone. Have a great evening. I look forward to seeing you week 5. Also, if you have to miss a class, I am recording each one of these classes, and just ask me for the assignment, the additional assignment, and you can make a point. You also have other ways to, like the OWL assignment and a couple of other ways to make up points. Don't worry about missing because I'm recording as I stated. So and the assignment is about you reviewing what I discussed and writing a brief paper on that to get those points that you missed by not attending. Okay. Just in case something happens. All right. Well, thank you. Have a nice evening. Good night.
Thank you.
Thank you.